Thank you very much for a nice presentation. I hope everyone enjoyed their lunchtime. And now we can start. This time, the first one, I want to take a moment to express my gratitude for the organizers, for the opportunity to present today. And to be honest, it's a great pleasure to present in front of such professional speakers. And so let me start. And I want to begin with a explanation what does industrial PhD mean and about my research a little bit, just to understand it better. As I'm undertaking the industrial PhD, is a joint project in between university and the Port Authority of Tarragona, that is located in Spain. And it means that I may get some insights from the port operations, because my research is focused on the risks in port operations and how do we cover that risks, how can we manage that risks. That's why for today's presentation, I have chosen the Prestige litigation, the case of Prestige. It seems to me to be interesting because it reveals how fragile the interface between risk, liability, and insurance can be when it's tested by a real-life disaster. As it was already said, that I'm going to examine how ports and maritime operators manage risks and how insurance is supposed to serve for this risk as a net. But as the Prestige case shows us, sometimes that net fails. So today I want to revisit the Prestige case, not simply as a legal precedent, but as a story that shows about the story about law, the story about insurance and international cooperation, and how all of that may collide in the time of crisis. So, okay, it works. And the central question after the Prestige case is the requirement for maritime civil liability coverage in ports compatible with the pay-to-be-paid clause if direct action cannot be brought against the P&I club? I've already heard that some of you may already have a question, but I think I have more questions than answers. Let us see. So I invite you to the journey of that Prestige case. And so let us go back to November 2002. So why do we talk about Prestige case more than 20 years after the disaster? As I see it, firstly, because it was one of the largest maritime oil spill in the European waters, with the long-lasting environmental consequences, economic consequences. And secondly, because that case clarifies a legal conflict that remains unresolved till today, like the tension between the rights of victims to be compensated and the contractual autonomy of insurers and ship owners. And for sure, because it speaks directly to the challenge that I am taking in my research. So how risk in port and maritime activities can be better understood and managed through the improved insurance coordination. So you may think, okay, that letter is going to be so slow and monotonous, explaining out 20 years of litigation, but it's not my aim today. But I have to highlight some main ideas to understand the case and what happened. And I want to bring your attention to the human part of the disaster that happened almost 20 years ago. So the Prestige was a 20-year-old single-hull tanker, quite old, in a poor state. And sailing off the coast of Galicia in Spain, the vessel suffered structural damage during a storm. After 6 days of drift and failed rescue attempts, the vessel finally broke into two and sank, releasing over 63,000 tons of heavy fuel oil in the Atlantic Ocean. You can imagine, so it became one of the worst environmental disasters in Europe history, as the spill contaminated almost 3,000 kilometers of Spain, Portuguese, and French coastline. If you compare to the coastline of Croatia, it's like double, probably. And so fishers were destroyed, thousands of families, they lost their livelihoods. The Spanish state spent billions and billions in cleanup and compensation. So it was a human reality that triggered a legal battle that would last almost 2 decades. And that is a moment where law enters. So to understand better the conflict, for me it was essential to say about two types of insurance that we have in maritime law. Liability insurance. This type of insurance protects third parties. The injured party is the beneficiary, and in that type of insurance, direct action is possible and natural. And indemnity or compensation insurance that protects ship owner. And in this case, direct action is not possible. So it protects the ship owner, compensating that economic losses of the payments that he has done to the injured party. So the Prestige disaster sat exactly at the crossroads of that two types of insurance, because Spain wanted to treat the P&I club insurance as liability insurance. So let me bring your attention to the insurance dimension for this case. The Prestige was insured by the London P&I Club. Unlike standard liability insurance, P&I insurance is a form of indemnity insurance. And that means that insurer does not step in directly to pay victims. Instead, the ship owner must first pay and then can be compensated or refunded. So that is captured in the famous clause pay to be paid. And in theory, it preserved the mutual nature of P&I clubs. But in practice, when the ship owner is insolvent, how it happened in Prestige case, it can mean that victims are left without nothing. So in the Prestige case, this became the decisive issue. Could Spain and other claimants proceed directly against the insurer? Or are they blocked by this clause, pay to be paid clause? So let us see how direct action works under Spanish law. Spanish insurance law and Spanish Maritime Navigation Act recognize the right of direct action. It means that injured party can claim directly against the insurer of the responsible party. This right is considered a matter of public interest and designed to ensure that victims are not left without uncompensated damages because of insolvency or whatever reason it can be. So this right is independent. This right is derived from the insured. It is based in law, not in the contract, and first of all, it's designed to protect the victim. And to exercise that right, we have fulfilled three conditions. The first one, a valid liability of the insurance, then a valid insurance contract, and a coverage of the liability under the policy. So in prestige litigation, Spanish courts have their conditions like they were satisfied. Therefore, victims could claim directly against London Pier 9 Club. Anything else? Spain argued that would be contrary to the public interest, the public policy, and justice. And let us cross the channel. English courts saw the matter differently. For them, paid to be paid clause is the foundation of the mutual insurance system. And the logic works like following, like that P&I clubs pool resources among ship owners. And that system works because indemnity is strictly observed. And if, in case, victims could bypass that structure, insurers would become de facto liability providers. And that is not the idea of P&I Club, and never, and it's not the intention of that. So for the UK, allowing victims to bypass, it would transform clubs into liability insurers and undermine the entire system of clubs. So therefore, the clause must be applied strictly, even if it leads to harsh consequences and victims were denied compensation. In that case, freedom of contract and the principle of mutuality were prioritized above victim protection. And as we can see in the Prestige case, it really did, because since the ship owner was insolvent, there was no payment, and therefore no obligation for the insurer to indemnify. As well as that, we have a European layer to that case. So when the dispute is scaled to the European level, the Court of Justice of the European Union has to reconcile these two legal cultures. So Spain insisted that its protective rules for victims must be recognized under European Union law, especially taking into account the environmental dimension. The UK, from the other side, defending contractual freedom and the global consistency of P&I insurance, they argued the opposites. So the European Court of Justice acknowledged both positions, but did not strike down the pay-to-be clause. And the message was like following. Well, national public policies matter, but so does contractual autonomy in international commerce. And fast forward in 2024, almost 20 years after the disaster, we are approaching to the last decision of the Court of Appeal of England and Wales from 2024 that issued its judgment in the case Spain against versus the London Ship Owner Mutual Insurance Association. And it confirmed that under the English law, the pay-to-be paid clause must be upheld. So since the ship owner, Mars Shipping, was insolvent in this case, the insured had not obligation to pay Spain or the victims. So what are the lessons from that case? We see that conflicts of law systems, they are real, that public policy rule versus private autonomy may exist, and that the case raises key questions, a lot of them, like, is liability insurance meaningful if victims cannot claim directly? Should the pay-to-be-paid clause remain absolute in all the circumstances? Or should environmental catastrophes be treated differently, like an exception? If not, are we ready to accept that victims of maritime disasters may face the same fate as those of the Prestige? Is it compatible to require maritime liability insurance in ports if the pay-to-be-paid clause prevents victims from exercising the right of direct action? So you may see that now I have more questions than at the beginning after my research. And the main question is, can indemnity insurance be accepted in the terms of obligatory port insurance? So let me show you main obligatory insurance that needed to allow vessels to enter to the ports from different perspectives. From the European law perspective, we have Directive 2009, Article 4, that's about insurance for maritime claims, that says that each member state shall require ship owners of vessels flying its flag to have insurance in place covering those ships. From national law perspective, we have in Spain, we have also some acts, Ports and Merchant Maritime Act about civil liability. Then we have a royal decree about regulation of on insurance for civil ship owner against maritime claims. And we have Maritime Navigation Act that says about compulsory insurance, and that says that civil liability insurance shall be mandatory for damages caused by pollution of coasts and navigate waters. And for sure, we have international conventions, CLC Convention, Bunkers Convention. So this is why that case matters for my doctoral research, as it focuses on risk analysis and insurance coordination in port operation. So the Prestige case illustrates to us exactly the type of risk misalignment that I study. So when contractual structures in insurance, they fail to respond to the realities of ports and maritime disasters. So if insurance cannot respond effectively in extreme cases, then the entire system of risk management in ports is undermined. Am I right? So in case the provided insurance by P&I flag to vessels cannot be used to protect the public interest, to protect third parties, as is required by law, this insurance is not going to be accepted then by port authorities if there is not this claim of pay-to-be-paid clause. So the Prestige case is not only about one tanker or one clause. It's about fragility, it's about collision of legal insurance structures. Thank you very much for your attention.